common, way too common.
My name is Janice Wolk Grenadier. I was given a 30-day sentence to jail yesterday in the City of Alexandria court. It was suspended for fighting for my right of due process and a judge with jurisdiction. Americans are unaware of how corrupt our system is, and that the judges, the Virginia State, the different boards are all patting each other on the back and basically taking care of their criminal actions. The judicial system polices themselves. There is nowhere to go. I have gone everywhere. I asked for a trial by jury and was denied it. I asked to go in front of a grand jury to ask for a special grand jury. I was ordered by the Supreme Court Justice Cynthia Kinzer to be allowed to go in front of the grand jury. Instead, myself and my witnesses were kidnapped into another courtroom and denied access to the grand jury. My evidence with 3 different judges has been taken out of my file and mailed back to me. I have a box that is unopened of my evidence.
Okay, you have to have a question for our panel.
I have a question as to what can we really do to get the government to, or somebody that is not that is arm's length, to look into cases like this. Where do you go?
Well, that's basically the sum of why I had to write the book.
You know, there are solutions. North Carolina had a solution with a rogue prosecutor. You all remember the LaCrosse case? And what...
the Duke LaCrosse case?
Yes.
The Duke LaCrosse case, a rogue prosecutor who eventually was disbarred and perhaps convicted. But they went further. North Carolina went further, and they passed a statute that provides for open discovery. Basically, if the prosecutor has it in the file, he has to turn the file over to the defense. And that seems eminently fair. This is not trial by ambush. We are not behind the Iron Curtain. We're in a system of due process. And it seems to me the defendant is entitled to know what's in the prosecutor's file. There's usually plenty there to convict, and most defendants at that point say, well, never mind, I'll cop a plea because they got me. But a lot of times there's stuff in there that the prosecutor may not understand to be exculpatory, because the prosecutor's job is not to figure out what's good for the defense, but defense lawyers are paid. So it's very simple. We have a piece of legislation introduced by 9th Circuit Senator Murkowski, co-sponsored by another 9th Circuit Senator.
It had 6 bipartisan sponsors.
So I'm very proud of our circuit for, but of course Senator Murkowski, because it was Senator Stevens from Alaska who suffered. So she introduced the Fairness Disclosure of Evidence Act, and then Cindy mentioned the Secretarial Integrity Act. You pass laws, and then prosecutors live by them. And if you shine a light on what is hidden there in prosecutors' files, then you will have a much better chance of having it. You don't count on people being honest or count on people being fair. It's just there. So that's what I would suggest. I would suggest we have legislation pending. It should be supported. It should be passed.
Thank you, Alan Gura. To what extent does the criminal defense bar put pressure on state bar authorities to take this more seriously with their powers of discipline? And to the extent that the state bar authorities may not be very responsive, what is the role of the federal district court disciplinary committees to actually discipline attorneys who appear before them? I know that Judge Kaczynski, for example, a long time ago in the Yagman versus Central District case dealt with a case where attorneys were criticizing judges, and those attorneys in that circumstance obviously get a lot of attention from the district court disciplinary committees. But if the state bar authorities are not much help, what about the judges themselves and their disciplinary powers?
I think that's a great point, and I actually drafted a Brady compliance order that I'm going to upload to the website too, that includes that as one of the steps the federal district judges can take. we tend to forget about that, but federal judges can decide that a lawyer's not fit to practice in their district or in their courtroom, and they have a lot of authority to start making waves in that regard. I don't know that the criminal defense bar is putting any pressure on the bar associations at all. I have no information on that, really. It took the Texas Court of Inquiry in the Michael Morton case that you all may have heard about. It received a lot of news and is now the subject of a book he's written. A man spent 25 years in prison accused of the murder of his wife while the prosecutor who hid the bloody bandana evidence, literally, became a state court judge, having run his campaign on his conviction of Michael Morton. Of course, the DNA on the bandana completely exonerated Michael Morton, thanks to the work of the Innocence Project over a number of years. The Texas Bar convened a special court of inquiry. That took an act of God and Congress, basically, to get that done. It resulted in the state court judge being arrested in open court, but he only served 10 days. I think, if we made the penalty, if you deliberately withhold evidence, you serve the length of time in prison that your victim wrongfully spent, that might kind of nip it in the bud. But yes.
I think what happens is judges have a certain expectation of what the lawyers before them will do, and it's particularly true of prosecutors. You expect lawyers to always tell the truth. You expect lawyers to always be entirely full square, particularly if you're a government prosecutor. And I think most judges have a hard time believing that the chicanery actually going on, and so they tend to be less likely to look for it or to infer that something is misconduct. I had a case about 20 years ago where the prosecutor made certain statements in district court. We then, same guy foolishly argued an appeal, so I asked him about it. And after hemming and hawing, he disclosed something that he had not told the district judge. He didn't want to do it, but I was pretty insistent. And it turned out to be quite key. And we sent the case back. We vacated the conviction. The case of Kojayan, United States v. Kojayan. You ought to read this. Good opinion. Well written. But we sent it back to the district judge to make a decision whether to dismiss indictment with prejudice or without prejudice. The district judge, a very fine, I should say, Republican maybe, although it really doesn't matter. It truly doesn't matter. A very experienced judge, had been a state court judge, had been a district judge for many years. The case came back, and he could not believe the answer that I got out of the prosecutor. He had been so convinced that couldn't possibly be the answer that he didn't even ask the question. He didn't press the question. Even though the defense lawyer said, ask him this question, make sure that... So what happened is the judge was so shocked by it, he dismissed the indictment with prejudice, which means the prosecution was dead altogether. I think most judges just can't believe this is going on. And my two colleagues in the Ramirez-Lopez case, I don't think they believed quite what was going on until they were pressed to do it.
Thank you for that comment. I'm afraid we have run out of time, but everybody here is invited to the luncheon we'll be having afterwards. Please thank our panel for a good discussion.